Good morning. My name is Guan Baokui, a practicing lawyer at AllBright Law Offices in Qingdao branch. Today, I'm happy to present this comprehensive guide on establishing a wholly foreign-owned enterprise in China. As an experienced legal practitioner in China for almost 20 years, we recognize the critical importance of proper WFOE establishment for international investors and also legal professionals. This presentation will systematically address the current regulatory framework under China's 2025 foreign investment policies, key procedural requirements for WFOE formation, common legal challenge and compliance consideration, practical solutions based on our experience. This guide has been prepared to provide foreign investors and also legal counsel with up-to-date information essential for successful market entry. We will examine both the strategic advantage of the WFOE structure and also the operational realities of establishing such entity in China's evolving business environment. At AllBright Law Offices, we have successfully guided numerous multinational corporations through this process, and we are confident this presentation will serve as a valuable resource for your Chinese market strategy. Let's now proceed to examine the fundamentals of WFOE establishment in China. First of all, allow me to introduce my professional qualification that inform this presentation on WFOE establishment in China. I hold a master's degree from Missouri State University in the United States, providing me with dual perspective on both Western and Chinese legal system. Currently serving as a partner at AllBright Law Offices in Qingdao, I led my firm's cross-border investment practice. My institutional roles including Vice Chairman of the Foreign Dispute Resolution Committee at Qingdao Lawyers Association, accredited arbitrator at Beihai International Arbitration Court, legal advisor to Blumsack Canzano PC, a U.S. law firm based in Massachusetts. My international practice is further demonstrated through membership in the Shandong Belt and Road Legal Service Team, appointment as independent director for multiple listed company, recognition as a recommended legal counsel by several embassies, including those of the United States, United Kingdom, Canada, Italy, and the European Union nations. With 20 years of focused experience advising foreign investors, I have developed particular expertise in navigating China's regulatory environment for international business, structuring compliant market entry strategies, resolving cross-border commercial disputes. This combination of international education, institutional rules, and the practical experience positions me to provide authoritative guidance for WFOE establishment, the subject of today's presentation. Let's now examine the fundamental concept of wholly foreign-owned enterprise, or WFOE, the cornerstone structure for foreign direct investment in China. A WFOE represents a limited liability company entirely owned and controlled by foreign investors. The preferred investment vehicle for international business establishment operation in China. A flexible structure accommodating diverse commercial activity, including trading and distribution, professional service and consultation, the manufacturing and production operation. Key characteristics that distinguish WFOEs include exclusive foreign ownership, no mandatory China partner requirement, operational autonomy, full management controlled by foreign investors, profit distribution, ability to remit earnings to overseas, legal personality, recognized as an independent Chinese legal entity. The structure has become particularly advantageous since China's foreign investment law reforms, offering foreign investors greater protection and market access. The WFOE framework now covers over 95% of the industry not listed on the negative list. For serious market interests, establishing of WFOE provides the optimal balance of control, flexibility, and also the legal protection in China's business environment. Now let's outline the strategic and advantage that make the WFOE structure the preferred choice for sophisticated foreign investors in China. The WFOE model offers four fundamental benefits that address key concerns of the international business. Complete operational control, full autonomy over business decisions and management, no requirement for local board representation, freedom to implement global corporate policy. Second, 100% foreign ownership, elimination of joint venture complications, no forced technology transfer to Chinese partners, protection of the proprietary business method. Third, independent market presence, ability to establish and protect your own brand identity, authority to issue official Chinese tax invoice, also named the terminology 发票, direct customer relationship without intermediary. 4. Profit repatriation rights, legal framework for dividend distribution overseas, clear foreign exchange regulations for capital movement, structured mechanism for royalty and service fee payments. These benefits collectively create what we call the golden triangle of the foreign investment in China: control, flexibility, profitability. The WFOE structure has become more and more particularly valuable since China's foreign investment law implementation, providing the stronger legal protection for those rights. For serious long-term market participation, this advantage typically outweighs the slightly more complex establishment process. Having understood the benefits of WFOE, let's now examine whether this structure aligns with your specific business objective in China. The WFOE model proves particularly advantageous for foreign investors engaged in professional service, including legal, accounting, and management consultation, cross-border trade, encompassing import and export wholesale distribution, technology sectors such as software development and IT service, manufacturing operation requiring local production facilities. However, critical restrictions apply to industries listed on China's negative list for market access, which currently include compulsory education in the institution, news media organization, and certain financial service sectors. Sectors requiring special approval beyond standard WFOE registration, value-added telecommunication services, certain healthcare and medical institutions. Before proceeding with your application, we strongly recommend conducting a comprehensive review of the latest negative list 2012-25 edition, verifying your business activities against the encouraged, restricted, and also the prohibited category, consulting with legal professionals regarding any sector-specific licensing requirements. The suitability assessment should consider both your current operations and the future expansion plans within China. Many clients find that while their core business may qualify, certain ancillary service might require alternative structure. Let me now outline the critical legal requirements for establishing a WFOE in China under the current 2025 regulatory framework. The successful registration and operation of your WFOE requires strict compliance with 4 fundamental legal requirements. First, precisely defined business scope must align exactly with China's standard industry classification, which means you cannot name whatever the business you want to do. You must need to use the terminology provided those by the Chinese government authority. All operational activities must fall within approved scope. Expansion requirements prior government authorities' approval. Industry appropriate registered capital. No universal minimum but must match operational need. Manufacturing typically requires higher capital than service. Capital contribution schedule must be strictly followed. Mandatory MOFCOM reporting. Foreign investment information report submission. Annual updates for material changes. Compliance with anti-money laundering disclosure. Dual-layer regulatory of compliance. We particularly emphasize that 2025 has seen enhanced scrutiny of business scope description, tighter enforcement of the capital verification, new data compliance requirements for certain sectors, proper documentation, and strict adherence to these requirements are essential to avoid any registration problem or delays or any operational restrictions. Many applications face rejection due to insufficient attention to those fundamentals. Let me now guide you through the essential 6-step registration process for establishing your WFOE in China. The first one is about the business name reservation. The process begins with selecting and reserving and approve the company name through the State Administration for Market Regulation. Your proposed name must follow all the legal requirements. Second one, the draft Article of Association. You must prepare the Article of Association, a legally binding document outlining your company's governance, scope, operational rules. Third one is business license application. With your document prepared, submit your application for business license, now integrated into Chinese 5-in-1 registration system, combining company registration, tax identification, social security, and custom code. Processing time, 5 to 10 working days post-submission. MOFCOM foreign investment filing. All for WFOE must complete a foreign investment filing with the Ministry of Commerce involving submission of the investment details and the shareholder documentation, compliance with the latest negative list, electronic filing through the national system, company sale and bank account setup, tax and social security registration. While this process appears linear, in practice, steps often overlap each other or require revisions. Professional guidance ensures seamless navigation, reducing typically 3 to 6 months timeline by 30% or 50% in our experience. Understanding the time and financial commitments for WFOE establishment is critical for effective planning. Let me outline the key benchmark you should anticipate in 2025. Timeline breakdown. Name reservation typically completes within 3 to 5 business days through SAMR's outline system, assuming your proposed name meets all requirements. The business license approval process now averages 5 to 10 working days under China's streamlined 5-in-1 registration system, provided your documentation is complete. From initial filing to operational readiness, the end-to-end process currently requires approximately 4 to 6 weeks for standard consultation or treating WFOE in most first-tier cities. Critical time variable. Manufacturing WFOE often required additional 2 or 3 weeks for environmental approval. Industry-specific license may extend the timeline by 1 to 10 months. Cost framework. Government authority fees and costs typically range between $30,000 to $5,000 for standard registration, but for most of the company, there's no charges or fees to be collected by the Chinese government authority. Professional fees for legal and accounting support at approximately $2,000 to $5,000 or maybe $10,000, depending on the complexity and the duration of the service for the whole period. Strategic recommendation. We advise our clients to budget for the upper range of this estimate to accommodate unforeseen requirements. Allocate an additional 15 or 20% budget for specialized industry compliance costs. Consider parallel processing of bank and tax registration to save 1 or 2 weeks. Based on our extensive experience establishing WFOEs, let me highlight the 4 most critical pitfalls that foreign investors must avoid to ensure smooth China market entry. The first one is the business scope errors. The single most common reason for registration rejection involves improperly drafted business scope description. Remember, your scope must precisely match China's standard industry classification code. Overly broad language will be rejected by authority. Future business activity not listed will require difficult amendment. Documentation non-compliance. Many applications face delays due to inadequate notarization or legalization of the foreign document, improper Chinese translation lacking official certification, missing apostille stamp for certain jurisdictions. Third, tax planning oversight. We frequently encounter failure to register for proper value-added tax categories, incomplete understanding of transferring pricing obligation, late realization of the withholding tax office, post-registration negligence. Many clients overlook these crucial follow-up requirements. Annual compliance filing with MOFCOM and the SAMR, monthly or quarterly tax declaration, even with zero activity, mandatory audit report for certain capital threshold, timely updates to license for any changes. Professional recommendation from my side. To mitigate these risks, we strongly recommend the foreign investors engaging China specialized legal counsel during initial planning, conducting thorough pre-filing due diligence, implementing robust compliance calendars, establishing relationship with a local tax advisor as early as you could. Key observation from my side. In 2024, more than 62% of the WFOE registration rejections we assisted with stemmed from those four avoidable mistakes. Proper preparation prevents costly delay and compliance risk. As we conclude this presentation, allow me to share 4 essential legal strategies that will safeguard your investment in China and ensure long-term success in the Chinese market. The first one is early engagement of the local counsel. Retain an experienced Chinese legal specialist during your initial planning phase, not only just during the crisis. Proper guidance on regulatory compliance from day one. Pre-approval of your business scope and structure. Ongoing monitoring of legal updates can prevent more than 80% of the common operational challenges our clients face every day. Bilingual documentation protocol. Implement strict process for official certified translation of all legal documents. Dual language contract with equal legal validity. Notarization or legalization of the foreign paperwork. Remember, English version alone hold no legal weight in Chinese proceedings. Comprehensive contract framework. Develop China-specific agreements covering supply quality control and penalty clauses, client payments term and dispute resolution, clear jurisdiction and governing law provisions. We recommend incorporating arbitration clauses specifying CTAC or other alternative international forum. Proactive IP protection strategy, which is also very important for foreign investors in China. These 4 pillars, legal guidance, documentation, contract, and IP protection, form the fundamental of the risk mitigation. Investors who implement this systematically experience 60% fewer compliance issues, according to our clients' data. As we conclude today's presentation on WFOE establishment in China, I invite you to continue this important dialogue. At AllBright Law Offices Qingdao branch, my team and I specialized in guiding foreign investors through China's evolving legal landscape. For detailed advice or further discussion, you can find the contact information, both my cell phone number, the WeChat, also the location of my office in my business card. Whether you are evaluating market entry strategies or navigating post-registration compliance, we offer industry-specific regulatory guidance, end-to-end WFOE establishment support, cross-border dispute resolution expertise. Let's transform these legal frameworks into your competitive advantage. Thank you so much for your attention, and I look forward to supporting your success in China in the near future. Thank you.